Greetings to everyone. Welcome to another episode of the Policy to Practice podcast brought to you by CDPP. This is with regard to our Law and Society episode series under our CLES initiative. Before we begin, let me start with a brief about what CDPP and CLES is. The Center for Development Policy and Practice is an independent research institution that focuses on economic and public policy issues, especially those impacting the marginalized and the vulnerable communities. The Center for Law, Economics and Society, or CLES, is a CDPP initiative which is dedicated to exploring and understanding the evolving legal landscape in India. Today, we are honored to be joined by Professor K.M. Baharul Islam, a distinguished scholar with over 30 years of experience in communications, corporate law, public policy, and governance. Currently, he's serving as the director and professor at Institute of Management Technology, Hyderabad, and a visiting professor at the London School of Economics. He is also the former chairperson of the Center for Public Policy at IIM Kashipur. In this episode, we will be exploring how rising judicial workload impact justice delivery, how systemic delays affect the lives of the under trials, and how India's prison system can be reformed to address the mental health crisis behind bars. Sir, welcome to today's episode. Is there anything that you would like to add to your introduction?
No, thank you for quite elaborate introduction. Let's get about it.
Yes, sir. Great, sir. So, the first part of our podcast would focus on the rising workload and capacity challenges. So, my first question to you is, sir, that how has the workload of judges in India evolved over the past few decades since independence, particularly in lower court, and how does the number of judges per capita compare with other countries?
Yes, this is a very interesting issue, which is there always. It is ticking like time bomb everywhere, but because very rarely we approach judiciary and a few people in the society, as far as possible, avoids police stations and courts. So people think it is an others issue. It is not touching me. But as a society, collectively, we have to bear the burden. Now, as you said, over the period of time, two things has happened, and why this? One is that we have inherited a British legacy of bureaucratic system. In a colonial India, in a colonial bureaucracy, a number of technicalities or formalities, you can say, and there are hundreds of laws which we have already prepared. But at the same time, we still continue to have some kind of technicalities and informal mindset within our official system. So on one hand, the people who are exercising law, executing law at various levels, whether it is a police station in charge or a vice chancellor of an university, both were using more and more in a kind of technical form of the law, the essence of law as an if you say that, if you can reduce it very simplistically to equity and justice, two basic principles of these were not followed as such, or were ignored at the altar of the technicalities. Rules have said this. Laws are interpreted to save individual, you can say, avoidance of some kind of technical lacuna later on. So people stick to those written rules, regulations. And whenever this will hurt or hamper a person's, interest in terms of equity, justice, and overall, our principles of the fundamental rights, Constitution of India, and all this, so they will approach court. So from simple leave application to increment to false imprisonment, think of any civil or criminal side, a large number of cases get piled up because the executives are not functioning on equity and justice principle. And so you can say the post-independence period, on one side, we continue to carry the British or colonial bandwagon in our working foundations. Laws which British themselves has discarded now, like Official Secrets Act or something like that. We carry them together till now. as sacrosanct. People who are in executive positions, they continue to exercise their power without any respect to equity and justice or fundamental principles, fundamental rights, essence of the Constitution, rights of citizen, rights of privacy. So they completely disregard that mostly. And then this gives rise to a lot of cases. Now, over the years, what happened, our citizens' awareness have risen. We have more law schools. We have more resources at our command, like this podcast or many other legal websites. We have live law. Everybody knows that bar and bench, those websites, people are coming to know about judicial decisions and what is wrong and what is right. The kind of awareness about how much whether the traffic police can take your driving license or not, it comes more from the uh, video lawyers than the classrooms or citizenship awareness. So this has also in law universities, legal clinics, NGOs, over a period of time, on the other side, there are a large number of people who are aware of their rights, so they're reaching courts more and more. The combined effect of this is that we have large number of cases which are pending. The data will show you we have millions of cases there. On one side, Law Commission says we must have 50 judges per million. But we are standing around even less than 50% of that around 2021. US has 2020. At one point of time, we can say, I can give you a kind of, the data I was pulled out was like USA has 107, UK has 51, which our law commission said. Germany has 250 per million. China has 194 per million. So on one side, the judiciary is overburdened. More people are aware, they're reaching the court. People are not taking things for granted. More lawyers, more people are getting, even from the civil society organizations are more. So all this is creating a burden. At the same time, while the number increase, the efficiency per se, or you can say disposal of the case per se, it still remains a worrisome point. And there are many reasons for it. Perhaps at a later point, we can discuss this if we can. So the scenario is that while if you look at the half glass full, we are more legally aware, more institutions, more education, more resources, online, offline, people are more aware. The half side empty is that while the society and the legal discourse or awareness have risen, the people who are actually, they are creating more cases for a simple issue of somebody's pension money will not be released by a egoistic head of office. Nahi deta, kya kar le. That attitude created more and more cases. They will ignore Supreme Court cases. If somebody given a reference to the case, are you showing me the law? Get your pension from the court. I'll not give you. That kind of attitude, and most of the time, what happens that many of these people can come to will learn law only from the shouts of a high court judge nowadays. If you open YouTube videos, so live courts, high courts, and judges, and their reprimand for the bureaucrats or any other officer, and I can see some of my fellow professors and principals and vice chancellor getting equal tough dose from the high courts. These are an eye opener. That how these people sitting in their office, they keep fundamental rights, equity, justice, privacy, everything to the toss, just because he is sitting on a chair and he has some law to grind, and that is increasingly and worrisome part of our whole system, where we see a lot of cases are ending up in judges' table.
Thank you so much, sir. So you mentioned the growing backlogs of cases, right? Now, just to add to that point, do you think the capacity, as in the hiring process or the recruitment process, adds to the reasons behind the growing backlog, or are there other reasons such as frequent adjournment and delays by lawyers themselves? Do you think these three reasons, in terms of the capacity building, can adds to the backlog?
Yes, absolutely. We did a very thorough study on this, which was commissioned by Ministry of Law and Justice. The report is on the website, in their website, which at IIM Kashipur, I led that project, where we try to develop a performance indicator for the judges. Just like a corporate sector, we have human resource and other, theoretical background of how judges or any functional person would work, and there must be some parameter against which they are, appraised over a period of time. So during this study, one part of was that why this delay, causes of delay, and then what kind of performance indicator we can add to the judge, the lower judiciary, the initial judges at the district and municipal level, at that point level, what we can do. So what we found, there are three angles, major angles, if I have the three bullet points of reading. One is that obviously that the illiteracy or the lack of knowledge on the part of the litigants themselves. So they're completely blinded. They don't, most of them do not have any homework or any cross check to do.
Yes. Yes.
Only few of them can have, they read the books themselves. They try to find out what is the case. They have their own opinion about the case strongly, and they get, that is one. So they're completely blind. There is an information asymmetry between the first stage lawyer and the client. Second thing is the lawyer themselves, most of the time, add to the delay. So second most important, and we had series of interviews with lawyers across India, particularly North India. We did that, and we found that that is the kind of at the end of the day, if I have to say kind of literary one-liner, then it is that biblical what Jesus Christ said: God should forgive them because they don't know what they're doing. So most of them are just doing what they don't know. So this also creates a kind of the lack of, and that's why there was another study which was commissioned, I think 2 years later by the same ministry, and I did that. And you will also find that report on the website of the Ministry of Law and Justice, which is about continuing legal education for our advocates. Every 5 years, the laws are changing 500 times, that the lawyer remains at the 50 speed. Now, this is not possible to retain your, license in many other countries, advanced countries, even Commonwealth countries like South Africa, Canada, Australia, where you have to show that you have upgraded yourself as a lawyer over the past, say, 120 hours of training you have taken, this you have done. So you have to prove to the authority, regulatory authority, to show that you are an active learning lawyer, and then you retain your license over a period of time. Here you see that we get what is called sanad from the Bar Council, and then it remains there, and you are a lawyer forever. No renewal, nothing should be. So a lot of these things also added at the legal. The third part, the third major stakeholder we talked to, and we had some, survey done among the judiciary, particularly the judicial officers at district court, or you can say first instance courts. There we have found that it is a kind of, one is a basically administrative and time management issues. Decisions are not delegated. Many of the things at the lower judiciary, the young judicial officers may not even dare to think of. There is a burden of seniority and tradition and the kind of things how it is done. That is one. So it takes some time for a young judicial officer to take some drastic measures to close a case. He is bound by precedents and giving times, and sometimes he feels helpless because both the lawyers will be conniving to take a next date. Sometimes it is genuine and sometimes it is. And another one is that because their verdicts or their judgments will be or may be seen by in an appeal by High Court. So many of them will take more time to grind to fix all the corners, look into these things, and because they fear to give some quick judgment, particularly in cases of bail, for example. The initial inertia will be, let me reject it, go to High Court and take it from there. Why should I put my neck into this? Maybe this is a high profile case, so he does not want to, attach his name to this high profile case. It was, that judge has given him, bail within 24 hours. Maybe it was needed, but the same guy will get the bail in 7 days from another place, from a higher court. So that is also a kind of hesitation. Another thing which I found during my interactions or our training, we used to deliver a training program from IIM Kashipur at the Uttarakhand Judicial and Legal Academy, Ujala at Bawali, Nainital. So in those days when we were delivering those, one particular component we wanted to do is that the time management and technology interventions. Now, this is where we thought that the modern methods of time management can be introduced in court. Many of these things are slowly coming up. We can see those in terms of the case records and other things which are available online, and many things are happening. But at the same time, the whole judicial machinery, including the officers, the registrars, and the clerks and the judges, all of them have to get into that bandwagon of time management, because the delivery of a judgment makes a lot of sense, because who else uh, can understand that the justice delivered in time is really just justice delayed is justice denied. Who can understand time importance of time than judiciary and people involved in litigation? So in these three areas, like administrative and time management thing, I say that is more operational. This kind of training and other things can be provided to the judges, which who can, because after a period of time, how we deliver, you see, it is for every profession, perhaps. By the time you reach district level, district judge level, where you are head of the judiciary in a district, by this time, your approach to dealing with cases have already gained some kind of stability, and in some cases, worst case scenario, it is fossilized. मैं ऐसा ही हूं. That comes into the top. So it has to come, if the time management sense of delivering, they must be accustomed, perhaps more important to send our young judges, and now you don't have to send them, partner with Canadian courts, British courts, have a kind of network, and then show how this functions without spending much time. Our young judges sitting in Ujala or any judicial academy, every state have that. They can have, then exposure to how things are done in other places. We don't have to necessarily reinvent the wheel or put the whole system upside down. Incrementally, we can do that, and we'll see that the people who are training in 2025 will see the result of their efficiency in 2035. Maybe in 10 years, they will continue to, over a period of time, we'll have a series of people who are in a modern system of, delivering justice, taking more help of, finding out the technological intervention in terms of their, the verdict validity. Now we are using legal analytics. So I can draft something and I can cross-check through my data analytics. I can cross-check with a large number of cases and judgments. That if I'm making something, this is just like an extension of our research methodology and research review. So young judges do not have to, reinvent the wheel again. That can save a lot of time, more scientifically. So legal analytics and other things can come into that area.
Thank you, sir. Actually, my next question was going to be about the technological aspect that you have already addressed. So, you mentioned that there are, of course, the advantages and disadvantages. But if we look into the challenges, what are the other challenges that remain in digitizing the court systems? And at the end, what are the other reforms or innovations that can be, thought of, which not only handles the rising caseloads, but also it remains efficient when it comes to ensuring a fair and timely trials? As you have mentioned, that if time management is given more importance, then fair trials are not happening. So how do we balance that, sir?
In today's world, if you have access to technology, affordable, easy, and which are given to you as a default, and if you do not use this, I think it is a crime against humanity. I can go against it. Till 2 years ago, I can shout at one of my students for writing a very badly crafted answer for an assignment. Today, with the help of ChatGPT and all kinds of Grammarly and software, I can't allow anybody who is on net for hours together during the day and then do not use the same technology to correct their English sentences. Today, I have no excuse that I am from a Hindi medium and that's why my grammar is weak and that's why please ignore this. Bhavna ko samjhiye, try to feel what I am trying to write. You may be writing the best argument in it, but if you cannot give me in a language which is acceptable. So, what I'm saying, technology is there are many theories about how people adopt or resist technologies. So technology adoption theory is one which has been well researched. But bottom line is that you have the eagerness to accept something which is already in and try to leverage and take the first mover advantage, or I say disadvantage, the advantage of the disadvantaged. So somebody who is in Delhi or who is in Hyderabad may not have to have an access to online library because he has 5 universities round by. He can take an auto or an Uber and get to a best library in Hyderabad. But imagine interior Telangana or interior Assam. There is a small college. They need the most urgent access to internet and library because they will not get a single latest book on law sitting in that small town. Can you imagine they are producing LLBs? What will be the quantity, comparison between Nalsar and that one atmosphere? So, but that principal who has internet given free, he does not go somewhere. He buys some bigger lock to protect his computer room ke koi chori na ho jaye. In village colleges, you see the government gives computer for and various schemes and various money. So they give those equipment. The principal is more worried about, and particularly the school headmasters, they are more worried about how to protect. In one study, we found that all the computers given, the headmaster is keeping a lock and key in his home. Why it is no school for the children? Saab chori ho jayega to meri naukri jayegi. So there is a mental issue of using the technology available. For example, go to YouTube or you ask any of your lawyer friend to log into any of this online court hearing. What is the quality of sound? Petty YouTubers are using high noise cancellation mics, which are available between 20,000 and 25,000. The best one can be at 30,000. And some of our High Court judges are talking and their voices are not heard to the other side. Senior lawyers are shouting, am I audible? The sound is... Why this should happen? Is it a mental block of 30,000? The technology is not available. The people who are managing that administration of that court do not tell to the others कि भाई सुनाई नहीं देती. High definition camera use कीजिए. How expensive are they compared to the money we spend in the system? So this is just a small example which can change. Hundreds of lawyers who log in from, because they are senior, they cannot travel from, say, lawyers from Delhi appear in courts in Guwahati or in somewhere in Meghalaya. Most of the time they feel uneasy because of this technology thing. And then the client thinks that because it was online, my lawyer did not travel from Delhi, I paid him so much money, the case is lost. He has not been harmed. And if you are alive, means you are live, you are standing there in the court itself, then you will find a bigger trouble to listen to your opposite party lawyer who is logged in from Bombay within the system. These are all small technical things which shows that the technical transformation is there, and many of our honorable judges are taking it very enthusiastically, and at least they have opened the door of the court to the world, to the citizen of India, who can see that the things and fundamental rights, how they're upheld by the court judges. Many of the people feel happy. We can see the comments and all. That's a digital history of our evolution from being citizen and now enjoying being citizen. When I see that somebody is arrested, being shouted at because the daroga has not done the job proper well, there is somebody, though that person, thousands of us, we do not have anything to do with that case. But as a citizen, we feel emboldened that yes, there is a judge sitting somewhere in Madhya Pradesh or in Himachal Pradesh. He is delivering the justice like that. So technology, what you were saying, I'm saying that it is more now of quality and connectivity concern. We have equipments. Earlier decades, we used to struggle with, how to dial in the networks. Now the connectivity is okay. We have broadband. We have quality and quantity. Now we need that last leap of quality transmission so that it looks more seamless rather than contrived one. So just to give an example, we do not invest in equipments. We just think that Zoom is so easy. Just you log in, you are driving, log in from your camera and do it. Perhaps you will save your job. You will show that you have attended the meeting or you have done something. But the feeling that that person has crossed the distance and talked to you, it may be a client, maybe a colleague in a project meeting, that feeling comes only when you have transcend that technological barriers. Now we have to focus on quality equipments, quality connectivity, real-time transition, and bringing that seamlessness between an online court and offline. The second thing, very quickly I'll add, is that while technology has advanced and many of our honorable judges have so proactively taken this that the history will remember them actually, while some of them are still worried about cameras. Even we teachers, we don't want anybody to watch us in our classroom. So the first time when somebody wanted to record my class or our classes, many of our faculty members, they resisted that this is a sacred place, temple of learning, don't put your camera here. Means I am worried of my mistakes, worried of that somebody will review this and find out that out of 1.5 hours, how much was coursework and how much was joke and how much was distraction. So we have this idea that nobody should watch us. We are doing something. Some people resisted even to show you your own marks, public service commissions. It took judges and courts and litigations to open that door. Otherwise, we teachers, we are more, what you can say, confidentiality conscious than the bureaucrats. We don't want to explain why I have given you 2 out of 10. If I have given 2, I have to justify. So first we said that no question asked, diya so diya. Second thing, I don't show your examination script. Third thing, I will not discuss why I have given 2. स्क्रिप्ट दे दिया लेकिन चलो मान लो देख लिया ना तो अब आओगे तो 1 कर दूंगा मैं रिव्यू में. So that we resisted, but courts have intervened. Public service commissions now, they have to open their answer script. They have to give the correct answers. So similarly, in judgments also, they should be easily and promptly available. Very recently, I saw the Honorable Chief Justice of Uttarakhand High Court actually issuing orders, issuing notification from that High Court that any downloaded copies of the judgment has to be respected. So digitally downloaded, paying fees or not paying fees, I don't know. I don't remember that part. But you can download your judgment, which is already typed and signed and confirmed from the High Court website, and give it to the parties which need to execute it. But till now, people were insisting on certified copy of the judgment. Now, this is the last mile of technology where it is just one notification issued in Uttarakhand High Court website. If you go and you'll see that a public notice is being given. Anybody who is downloaded from the official website, a copy from the official server of the website, it is as good as certified copy. It does not need to have those, mohurs and signatures for somebody to act it upon. So in one stroke, he has saved millions of days. People used to languish for this certified copy, 2 days, 3 days. Crucial examination cases where students are given chances to appear in an exam or so, where every hour is important. This insistence on certified copy in a digital world is something unheard of. So this is the last mile which we can cover in terms of technology advancement and delivery of those tools. Perhaps that is one thing we still have to do.
Thank you so much, sir.